Reservation is an instrument of affirmative action by the state so as to ensure all inclusive march towards the goals of an egalitarian society while counteracting inequalities. It is an instrument not only for inclusion of socially and educationally backward classes to the mainstream of society, but also for inclusion of any class or section so disadvantaged as to be answering the description of a weaker section. In this background, reservation structured singularly on economic criteria does not violate any essential feature of the Constitution of India and does not cause any damage to the basic structure of the Constitution of India.
As well settled, it must be presumed that the legislature understands and appreciates the needs of its own people. Its laws are directed to the problems made manifest by experience, and its discriminations are based on adequate norms. Therefore, the constitutional amendment would not be struck down as discriminatory if the state of facts are reasonably conceived to justify. As laid down by this court, just as equals cannot be treated as unequals, unequals also cannot be treated equally. Treating unequals as equals would be as well offend the doctrine of equality enshrined in Article 14 and 16 of the Constitution. The SCs, STs and backward class for whom the special provisions have already been provided in Article 14, 15.4, 15.5 and 16.4 form a separate category as distinguished from general or unreserved category. They cannot be treated at par with the citizens belonging to the general or unreserved category. The impugned amendment creates a separate class of EWS from the general or unreserved class without affecting the special rights of reservations provided to the SCs, STs and SCBCs.
Reservation is not an end but a means to secure social and economic justice. Reservation should not be allowed to become a vested interest. Real solution, however, lies in eliminating the causes that have led to the social, educational, and economic backwardness of the weaker sections of the community. As larger percentages of backward class members attain acceptable standards of education and employment, they should be removed from the backward categories so that the attention can be paid towards those classes which genuinely need help. In such circumstances, it is very much necessary to take into review the method of identification and the ways of determination of backward classes, and also ascertain whether the criteria adopted or applied for the classification of backward is relevant for today's conditions. The idea of Babasaheb Ambedkar was to bring social harmony by introducing reservation for only 10 years. However, it has continued past 7 decades. Reservation should not continue for an indefinite period of time so as to become a vested interest.
Impugned amendment creates pathways, gateways and opportunities to the poorest segments of our society, enabling them multiple access points to spaces they were unable to go, places and positions they were unable to fill, and opportunities they could not hope ever to ordinarily lose due to their destitution, economic deprivation and penury. These destitution, economic deprivation, poverty are markers or intelligible differentia, forming the basis of the classification on which the impugned amendment is entirely premised. To that extent, the amendment is constitutionally indefeasible. However, by excluding a large section of equally poor and destitute individuals based on the social backwardness and legally acknowledged caste stigmatization from the benefit of the new opportunities created for the poor, the amendment practices constitutionally prohibited forms of discrimination. The net result of the entire exclusionary principle is Orwellian, so to say, which is that all the poorest are entitled to be considered regardless of their caste or class, yet only those who belong to other classes or caste would be considered, and those from socially disadvantaged classes would be ineligible. Within the narrative of the classification jurisprudence, the differentia or marker distinguishing one person from the other is deprivation alone. The exclusion, however, is not based on deprivation but social origin or identity. This strikes at the essence of the non-discriminatory rule. Therefore, the total and absolute exclusion of constitutionally recognized backward class of citizens is nothing but discrimination, which reaches to the level of undermining and destroying the equality code, and particularly the principle of non-discrimination.
I have concurred with the view taken by Honorable Justice Ravi Thakur in its entirety. So effectively, the decision speaks to both. Rendered by the majority consisting of Honorable Justice Dinesh Maheshwari, Honorable Justice Bela M. Trivedi, and Honorable Mr. Justice J.B. Pardiwala. The challenge raised to the 103rd Amendment to the Constitution fails. The writ petitions and other proceedings filed in that behalf stand disposed of accordingly. Thank you.
Grateful to you.